So these are different types of intellectual property. So this is patents, designs, trademarks, GI, copyrights, and there's something known as SICLD also, which is semiconductor integrated circuits layout design. So if you are from electrical background, so you can this SICLD would come under that. So this is work talks about integrated circuits layout and design, etc. So each one of this intellectual property has an act and a rules. Okay, just like you have Patents Act. Patents Act is 1970. Designs Act 1999. Okay, Trademarks Act, Geography Indications Act, Copyrights Act 1956, etc. So this again SICLD. So these are, you have different acts and rules, and what we do is like me being examiner of patents and designs. What I do is that if I get an application, I would see whether it is accordance with this act and rules, and if it is in accordance with this acts and rules, I am able to grant you a patent or grant you a design right. Okay. So as you first, if you must have seen, like if you must have noticed that I'm just examiner of patents and designs. I'm not an examiner of trademark. There is separate post for examiner of trademark, and there is separate post for examiner of geography indications or examiner of copyrights. So I'm just examiner of patents and designs. So my work is like examining applications related to patents and designs. My specialization is metallurgy. So I examine applications related to metallurgy field. So similarly, there will be field in respect with, say, suppose computer science or electronics or physics or chemistry or any other scientific discipline. You would have examiner of that particular stream, and you would be examining those applications. Okay. So if you can see in this example over here, so here you can see it's an Apple laptop. So this laptop, you can see this LED is so one IP, one product has different IPs. Okay, so I'm having a mobile phone in my hand right now. So this mobile phone has around 2,50,000 patents. Okay, this mobile phone has 2,50,000 patents. So similarly, this laptop which you're seeing in this screen right now, this laptop also has different IPs. You have a patent, you have LED display would come under patent, body of the laptop would come under design, the Apple sign would come under trademark, the user manual would come under copyright, and layout of the integrated circuits that would come under SICLD. So what we learned from this slide, one is that you have multiple IPs for single product. It's not that you have a product means you are protecting a total product. No, you have different IPs in a single product. Similarly, you will have multiple IPs for single product, as well as you will have variety of patent. Like suppose, for example, this LED display would come under patent. So if I'm having a mobile phone, okay, let's take this example. I'm having a mobile phone. What would be the patentable features of this mobile phone? One would be the touch screen. Okay, one would be the swiping feature. That will also come under technical features. And another thing like suppose security features, that also come under patent. Okay, so the design part would be the design of the mobile phone. Say the design of Apple phone would be much iPhone would be much different to that of, say, a Samsung phone or a Motorola phone. So design would be different. Okay. So the next example is of a TV. So everyone watches TV. So yeah. So TV, in this TV, you can see the remote control mechanism, the how we operate those channels, toggle those channels and volume control. So that would come under patent. Okay. And design is the aesthetic view of the TV. That would come under design. The trademark is a Sony logo. If you like remember this IP India, I had showed that logo. So logos, wherever you see a logo, that means you're having a trademark. Say you're building a startup, and say suppose for example you're building a startup like an Apple. So Apple has this Apple ka logo, you must have seen. So they must have protected that Apple logo under trademark. Okay. Similarly for copyright, so TV instruction manual can be protected by copyrights. Okay. Okay, I have a question here. Tanmay is asking, under what category will source code of Mac operating system fall, patent or copyright? Yeah. So this is a good question. I'll come later to something known as non-patentable inventions. Okay, non-patentable means which are not patentable under Indian Patents Act 1970. So there is something known as Section 3K of Indian Patents Act 1970. It says that source code and business algorithms, whatever coding you are having, so that would not fall under patent. Okay, it might be possible that you are patenting it in US Patent Office, but this thing would come under copyright. Okay, the source code of the Mac operating system any source code for that matter would come under copyright, don't fall under patent. Okay, I hope I answered your question. Host of this meeting, can you just stop this annotating? This is a little distracting.
Sir, actually, I'm clearing it from my side, but there aren't any specific controls that can actually stop them.
Okay, I would request to stop annulling this thing. It will break the continuity of this presentation.
Yes, sir. Yes, sir. I'm working on it. I'm sorry for the inconvenience.
Yes, sir.
All of you all, please.
Okay, Tanmay is asking, so how do we compile that? Because it is said that we have to have compiled 20 pages or something like that. Compilation of source code, again, is a little technical feature. I won't be able to comment on that. I can say that it falls under copyright for sure. It doesn't fall under patent. Yeah. So I'll continue my presentation. Okay.
So, sorry to interrupt, but the annotations actually you will have to turn them off from the screen share setting. You have the control on your device.
Let me just see. Remote control, disable annotation for others. Yeah. Now it's done. So I'll continue my presentation. So this is a TV, as you saw. Like TV has different IP rights. Okay, you have patent, design, trademark, and copyright over here. So the next example, the third example for the day is Coca-Cola bottle. So Coca-Cola bottle. So what are the multiple IP rights over here? One is shape of the bottle. The shape of the bottle fall under design. Okay, and the logo Coca-Cola, that is a trademark. Okay, and patents is the bottling equipment, that would come under patents. Okay, and copyright is in respect of text, database, or artistic work appearing in website, that would come under copyright. So a single product can be protected by more than one IPR. So there is something known as trade secret. Means you're not applying for a trade secret, means you're keeping it as a secret. For example, the formulation of Coke. Okay, so this is an imaginary situation where Coca-Cola headquarters is in USA. Okay, so you are formulating the Coca-Cola composition, that liquid. Then after that, you are okay. Food experts like FSSI, which you have in India, use something known as FDA in USA. Those people have come and maybe checked for it is safe for human consumption or not, and then you have seen that okay, this is safe for human consumption, and it has kept in as a trade secret. Like you have written that composition on a piece of paper, and you have locked in maybe a closed chamber somewhere in US headquarters in USA, Coca-Cola headquarters in USA. So that is a trade secret. So you are open to keep as well as trade secret, but it is at your own risk. You won't get any royalties for that. You won't be able to publish your invention to someone, but it will be kept as trade secret. It is at your own risk. Just a second. Yeah, now it's working. Hello.
Yes, 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 so we are trying. Just give us.
Yeah, now it's working. Yeah.
Okay, thank you, sir.
So you can see over here there is this Coca-Cola bottle. As I said, this Coca-Cola formulation has been kept as trade secret. Okay. So the Coke, the higher command of Coca-Cola, what they have decided is that okay, we will keep this as a trade secret and not applying for a patent or a trademark, etc. Okay. So this is a very simple like slide where you need brain, resources, and labor. Brain, as in not the biological part, but the idea part. That you need some ideas, you need some resources. You need resources, as in if you're say working in a chemistry lab, you need beakers, you need test tube, you need chemicals to mix, and you need some kind of labor also. Labor is like required for any physical task to get completed. Okay, and okay, what is the importance and significance of having an IP? You can protect your invention. Okay, you can protect your IP right. You can exclude others from using your IP right, and you can utilize, commercialize, and earn through your invention. Okay, so uh, yesterday there was a match between India and West Indies, if you remember. Yeah, so there is this there was this match between India and West Indies, and there was an invention on the cricket field also. If you must have noticed, that is this LED stumps, the zinc stumps. So the zinc stumps was invented by a person in Australia. Um, so that person, what he has done was he has protected that invention. What he has done was he has kept an LED light bulb into the bale of the stump, and after, as soon as the ball hits the stumps, the bale falls and the light glows. So at a distance, you can make out that the stumps have been broken or not. Okay, so this is a invention. Now what he has done was he has applied, he has gone to each and every patent office all over the world, like for example in Australia, in India, in US, in Europe, in Japan, and he has filed for his invention and he has got a patent. Now what he has done is he has excluded others from using this invention, and he is utilizing it, commercializing it, and earned through his invention. Now he is earning in multi-millions just with this in one invention of having this light bale. Okay, now he has earned multi-millions with this invention. Okay. So the next slide over here, this is what is the significance of having an IP right? For common person, it is a matter of pride that you're having a patent, you're having a trademark. Apart from it, in academics, like if you're applying for research positions, even after like maybe you're got maybe you're working as a professor here, or maybe you're as a PhD student, you want to apply for say postdoctoral research. Patents would help, definitely to help, and research papers would help. And apart from it, if you're a businessman, definitely like if you can commercialize it, if you can earn and invest in invention. Okay, I like to ask a small question over here. So why are Apple phones more costlier than Samsung phones? Have you ever wondered like why Apple phones are more costlier than Samsung phones? Any idea? You can type your answer on the chat box. Brand value. Rishit, yes, right answer. The answer is brand value. It is because of this brand value, the Apple phones are much more costlier compared to Samsung phones. And more than just brand value, you're having a lot of patents with their name. They're having a lot of patents in their name, and after that, due to that, brand value increases. Yes. So you can see in the slide over here. This is Apple. Apple has a brand value of $241.2 billion US. So this is brand value. This is much more compared to Samsung. Samsung is in eighth position. Okay, so you can see over here the brand value is much higher compared to Apple with respect to Samsung. This is because of IPR rights. Okay, Apple has protected their phone so much that automatically the brand value increases. Okay. So we'll come to the first IP right of the day. What is patent? Okay. So you need to get basics clear. What is patent? So if you're encountering any keywords like technology, inventive step, technical features, so that would fall under patent. Novelty as in newness or some kind of technology is involved, that would come under patent. Okay. So patent, you are getting an exclusive monopoly right for 20 years. So some keywords over here is exclusive and monopoly right. Okay. Another is period of 20 years. You are getting this monopoly right for a period of 20 years. In exchange of what? In exchange of your full disclosure of your invention to the government. Okay. So the basic three requirements for getting a patent is novelty, inventive step, and industrial applicability. So what is novelty? Novelty is newness of this invention. Inventive step is technical advancement over the previous existing invention. So that is inventive step. Industrial applicability is, as the name suggests, it is whether it is applicable to in industry or not. So 99.9% of inventions which come to our table, all of them are industrially applicable in nature. So there is no problem in that. Okay. So there is no problem in that. So the only problem is novelty in inventive step. So what is novel? What is inventive? Okay. Novel is like just like in the year 2020, in the month of March 2020, there was this novel coronavirus. Okay. There was this novel coronavirus. So novel coronavirus is, as the term suggests, novel. Novel means new. No one knew before what was coronavirus. So it was termed as NCOV, novel coronavirus. So that is novel in nature, that is new. So what is inventive step? Inventive step is the latest variants of coronavirus, like BF7 or some like recently in Israel also there was a new variant they found out. So that is also a inventive step. That is a technical advancement over the old coronavirus. So that is an inventive step. So you need to have these three requirements fulfilled. So this is under section 21J of Patents Act 1970. Okay. Some history facts over here. So this was this person, George Alfred D. Penning. He was the first person to get a patent. So at that time, there were no examiner of patents. There was no controller of patents. There was no actually before independence. So there was this Viceroy of India or Governor General of India. He was the examiner come controller of patents. Okay, so he used to examine those applications and then they used to grant them patent. So this was his person, George Alfred D. Penning. He was the first person to get a patent for efficient Panka pulling machine. Okay. So some of the scientists and inventions name you can see over here: Thomas Alva Edison for phonograph, Alexander Graham Bell telephone, Wright brothers aeroplane, Louis Pasteur rabies vaccination, Alexander Fleming is for penicillin. Okay. So as soon as I tell the name of Thomas Alva Edison, what strikes in your mind? Any answers in chat box? As soon as I tell the name of Thomas Alva Edison, what strikes in your mind? Any answers in chat box? Light bulb. Varun, yes, right answer. Light bulb. Yes. So light bulb was invented by Thomas Alva Edison. Moreover, Thomas Alva Edison was the first person to file for a patent. That is why his name is famous. There were reports also, if you see in internet articles, you must have seen that there are a lot of scientists even before Thomas Alva Edison to invent the light bulb. But Thomas Alva Edison was the first person to patent it. Okay, so that is why patent is important, so that you can, like, now even after 100 200 years you're able to tell that Thomas Alva Edison means for light bulb. It is just because that he has not only invented it but also patented it. Okay, so these are some of the inventions which we come, like this comes to a table, like this is a very shower cap. Okay, where this water gets diverted from the eye of the baby, and this is a wristband where the mobile screen is projected onto the hand. Okay, and this is card reading device where you need not this is card reading device where you need not enter all those details, this 16-digit number, expiry date, nothing. Just swipe it and all the card details get captured. And this is his drone. Drone is not used for defense purposes, but it is for it is for maybe some pizza delivery or Zomato, Swiggy, food delivery startups. Mostly, if you see, like they have this drone mechanism, This is slowly developing. Maybe this is an idea for you, like drone delivery for maybe for not for defense purposes, but for daily use, like for pizza, medicine delivery, etc. So this could be new ideas for the startup. Okay. So these are all patented technologies. So another is that this was I was telling earlier. This person Bronte Ekerman. He had invented the zinc stumps, and as I said, and he's a Australian mechanical designer created by South Australian manufacturer. This is known as zinc wicket system. Okay, zinc wicket system. This is a news item where our Honorable Prime Minister Sri Narayanamurthy had mentioned about patent and trademarks in his Man Ki Baat address in January 2023. So this is long back. So this is the first time in 11 years in India, number of domestic patent filing is more than 0.5. Okay. So this is just a news item. Okay. So this is a celebrity patent. So what is celebrity patent? So this is Michael Jackson, the king of pop, had patented special shoe for creating anti-gravity motion. So any pop song lovers, can you tell me the name of the song? Can you tell me the name of the song where this Michael Jackson is performing this dance step? Or you can tell this name of this dance step also. Yes, smooth criminal. So the answer is smooth criminal. That's the right answer. Yeah. Oh, smooth criminal. Nikola Tesla. Yeah, he is also smooth criminal. Smooth criminal is the right answer. So the if you see in the left hand side corner, you see this US number, US 5255452. This is the patent application number which he has filed for. And after you get a patent, you also will get a patent number for it. After the grant of patent, you will get a patent number. So this he has Michael Jackson, what he has done, he has applied it in US patent office. So he has got a patent for this. Okay. And I would like to tell over here, patents are territorial rights. Patents are territorial rights. Okay, means if you want a patent in India, you need to apply to Indian Patent Office. If you want to patent in US, you need to get a US. You go to US Patent Office. If you want to patent in Japan, you need to go to Japan Patent Office. So patent is there is no something known as international patent. No. There is international patent application, but that is a different thing. But again, you need to apply for a patent in a particular patent office to get a patent because India is sovereign country. So India, you get a patent in India only. If you are applying for a patent office, if you are applying for a patent in patent office India. Okay. So some patent application filing. There are multiple forms in patent office, patent act, like literature. There will be a lot of patent forms, but you need not file all those forms. Only the forms which are required to apply for a patent are only three. That is Form 1, Form 2, and Form 18. Form 1, what is Form 1? Form 1 are details of application, applicant details, address of service, and proof of right. Those kind of details are in Form 1. Form 2 is the details of invention. This is the main part where you will describe your invention in words. Okay. And this should, if it exceeds 30 pages and if it exceeds more than 10 claims, in that case, you need to file for extra fees, but fees is not required for 30 pages and 10 claims. So what would be the example of a claim in a patent specification? Say for example, I'm having this mobile phone here. So mobile phone, first feature would be, this is a swiping, this mobile phone has a swiping feature. Okay, that is claim 1. Claim 2 is, you are having a camera in this mobile phone, which has certain megapixel. This is claim 2. So in that way, you draft your claims, which you have each technical feature has been explained thoroughly. Then after that, you apply for a patent. Then after that, you have Form 18. Form 18 is where you request the examiner to examine your file. And there are other forms also like Form 3, Form 5, etc., which fees are not required. So for Form 3 is you can file later also, there are no issues. You can file later. But Form 1, Form 2, and Form 18 needs to be filed so that you can say that I have filed my application in patent office. Okay. Yeah, so these are the fee details. Fee details, it depends on the person to person. Say, suppose you are working in a company, a full-fledged company. In that case, the fees is a little higher. If you are working in a startup, or if say you are in this education institute, so that the fees would be much lesser. So the fees would be around 5,600 rupees, and for if you are working in a company, it's 28,000. This is and it you can refer to first schedule of patents rule 2003 for exact fee details, because this 5,600 could be much lesser also. If you are having a particular type of say patent specification, it could be much lesser. It could, if you are say applying, if you're coming to office and applying, then in that you can you are getting, you have to pay for 10% extra. Okay, so patent application processing. So you have formal examination, you have technical examination. Formal examination is you just check for the forms filed in that examination. And technical examination, as I said, there are three things. Technical examination, there are three things. One is novelty, inventive step, and industrial applicability. So these three things you check for technical examination. Okay. And what we do is something we send to the applicant, which is known as first examination report. In this, we send a gist of objections to the applicant. Apart from it, this is not an FIR. This is FER, first examination report. FIR you must have encountered in say police or law. You must have encountered about this FIR. So this is not FIR. This is FER, where we first examine and then send a report. Then after that, controller takes a decision whether to grant you a patent or not. Okay, before taking that decision, he schedules a hearing with the applicant. Okay, so these are some basic timelines. I'll request ma'am to circulate the slides among yourself so that you get to know what are the details. Like provisional to complete is 12 months, request for examination is 48 months. So these timelines are not hardbound in nature. You can file a petition under Rule 137 to the controller, and then you can bypass these timelines. Okay. So this was there was this question asked regarding the source code. Okay. So these are non-patentable inventions in India. So this falls under Section 3 of Patents Act 1970. So what are non-patentable? Okay. So non-patentable is, say for example, you are at your home, and with your help of your powerful telescopes and binoculars, what you have done is you have spotted a planet. Okay, once you spotted a planet, and then you come to patent office and say, and this planet is mine because I have discovered it first. So this is just a discovery. This is not an invention. You need to understand what is discovery and what is invention. Invention is something new, which is not there in the universe. It's something new. Discovery is already there in the universe. You have just discovered it. Like discovery of moons of a particular planet, that would come under discovery. But that is not an invention. You haven't done new anything with that. Okay. So that is non-patentable invention. This is a not patentable in India. Apart from it, you have rearrangement of known devices. That falls under Section 3F. What is mere rearrangement means? I'm having a mobile phone, I'm having a microphone, I'm having a camera. I have attached these three devices and said, okay, this is rearrangement. So this is not patentable in India because these three already are distinct inventions. You have just clubbed those three inventions and said this is a patentable invention. No, this is not possible. This is not patentable in India. Apart from it, you have frivolous inventions or which are against natural laws. You are supposed say claiming an invention where you say that sun rises in the west. So I'm having a question over here, sir. But newly discovered land, can it be patented? No. Land, for example, is not an intellectual property. First of all, land is a immovable property, but it's a tangible property. It is not an intellectual property. First of all. So it doesn't fall that I can't say that it is patentable or not. It is not, it should be registered. It can be registered under whatever act law you have for land authority, like you have land registration office, property registration office. So over there you go and you register your name against that land. So that is not a patentable thing. First of all, it doesn't fall under intellectual property, land. Okay. Another is mathematical business method or algorithms. This falls under Section 3K. Okay, plant animal therapeutic treatment is not patentable in India. So next is designs. So designs over here is, you can see over here, this is a L-shaped sofa. You have single seater sofa, double seater sofa, etc. You have hand sanitizer bottles. You must have seen of different designs. Okay, and then you must have seen this mask, coronavirus. During the time of coronavirus, you must have seen a lot of different masks like N95 mask, cloth mask, and like you have this multi-layered mask. You have two-layered mask, etc. So these are different designs used, and another of watches like Sonata, Rolex. You have different Titan, Timex, etc. So these are, you have different watch brands. So can you tell me this name of this machine over here, which is this blue in color? This one. Yeah, it is lathe machine. Right answer. It is a lathe machine. So what is lathe machine? Lathe machine is the machine used for manufacturing of gears. So gears you must have seen in like in a bike or in a motor where mechanical equipment is involved, where you need a particular teeth of a gear. So that needs intricate design for that manufacturing of that gear. So that is why I included in this slide. This is known as lathe machine. Okay. So we come to designs, which is the second IP, right? So designs, you have Designs Act 2000, Designs Rule 2001, and so some of the keywords over here is shape, configuration, pattern, ornament, composition of lines or colors. Shape, configuration, pattern, ornament, composition of lines or colors. So these are, if you find these keywords, then means it comes under design. Okay, the term of design is 10 years, extendable to 15 years. Patent mein what are the keywords? Technology involved, inventive step, novelty, and some technical advancement, some kind of technology is involved. So that is patent. And in design would be shape, configuration, pattern, ornament, composition of lines or colors. So term of design is 10 years. Okay. What was the term of patent? Any answers in chat box? What was the term of patent? 20 years. Yes. 20 years. Yes, right answer. So term of patent was 20 years. The term of design was 10 years. Okay. So you can, this is a self-explanatory side where you can see a lot of shape bottles. Say one product of Dove, this could be a body conditioner or body shampoo, has different designs. So they have marketed over the period of years, they have marketed with different designs. Okay. And they have each protected that design in the design office. Okay. So can you tell me the name of this product on the left hand side and the right hand side? This is very easy. Just by looking at this product, Harpic and Collins, Varun, yes, right answer. Rishit Patel, Avantika, yes. The answer is Harpic and Collins. So the next question is, how are you able to tell that it is Harpic and Collins? Because though I have removed this label over here, yes, the design part, yes, the design part, and also any other answers? Design to here, bottle designs, yes, color, Varun, yes, the color combination. The blue and the red one shows that okay, this I have seen this earlier. This like you're recollecting this from subconscious memory. Okay, I've seen this somewhere. This is Harpic because I'm just striking into my subconscious memory and telling okay, this is Harpic. This is Collins. Okay, this is color combination and design part. This is the case study where Range Rover Evoque and Landwind X7. So what they have done is one of the companies over here has infringed the design of the other company. What is infringed? Infringed is you're kind of replicating the same design which has already been registered in design office. Okay, so you can say in simple terms that one person has copied the design from another company. Okay, so you can see over here this is a side view of both the SUVs. So one company has completely copied the design of another company. So so now it is a matter of courts. So patent office doesn't do policing. We are not in the policing terms or going in the market and checking and seeing who is doing wrong. No. We are here only giving you protection. Okay, this is a matter of courts that it is a matter of courts that one person has to file a suit against the other person that this person has copied the design from product design. So the question over here is, can still case be filed again after this? Yes, case can be filed provided you have a design right and you have a design certificate in your name, and then tell that okay, this thing is this design belongs to me, and this company XYZ company has stolen the design from me or has copied the design from me. I need this much compensation, and this is valid in court of law. Okay. So the next question is, sir, what are the scopes of IPO in company? IPO as in intellectual property or initial public offer? So I'll come to that later. Let me first discuss about each and every IP right. Then after that, I'll tell you how to manage which IP right in which company, etc. How to manage your IP right ecosystem. Okay. Yeah, does help a lot. As I said, for a common person like you are, it helps you in academics. It helps you in. Okay, so the question is, how does IPO helps in college students? Helps for college students. Okay, so college student के लिए क्या है? आपका अगर better research position चाहिए, आपको अगर मान लीजिए आप कोई research position में ये करना चाह रहे हैं, R&D में कोई काम करना चाहते हो, तो in that case, what you do is you have a patent in your name, you have a trademark in your name. It helps you build your resume and it helps you in getting your dream company. This is for placement. Another thing is for research position. Suppose if you want to work in research, you want to do some PhD, or you want to apply for a better professor position maybe in some college. Over there also patents do help. Okay, so it helps in that way. So we have 4 offices: IPO Delhi, Mumbai, Chennai, and Calcutta. IPO as in is full form is Intellectual Property Office. Okay. The question you're asking over here, Vishwanath, the question you're asking over here is IP rights. So it's not IPO, it is IP rights. Okay. So you have 4 offices over here: Delhi, Mumbai, Chennai, Calcutta. I work in IPO Mumbai. Okay. So Mumbai has particular jurisdiction, like for example, Maharashtra, Goa, Madhya Pradesh, Gujarat, etc. So these states are covered by IPO Mumbai. So similarly, Delhi, you have Uttar Pradesh and Punjab, those regions, Rajasthan, etc. So this slide talks about digitalization, where our office is a completely paperless office. Okay, you won't see lying papers here and there. All of them are electronically e-module types. So everything is digitized and it goes into patent office. So for the design applications, what we do is we digitize those applications and we send to Calcutta office. So Calcutta office is a kind of head office for design applications. Okay. In patent, I must have told this, there are 3 forms for patent. One is Form 1, Form 2, and Form 18. So in design thing, you need to file 3 forms. One is Form 1, Form 21, and Form 24. So these 3 forms you need to file. Why I'm telling Form 24 is because you are having a startup. So for a startup, you need to file Form 24. Similarly, for applying for a patent in and you want to say fee concession by a startup, you need to file Form 28. Okay, so this is a certificate you get after your design is registered. This is known as Certificate of Registration of Design. So this is signed by Controller General of Patents, Designs and Trademarks. This is white in color. So this is white in color, and similarly, patent ka jo certificate rehta, that is blue in color. Okay, and this is signed by the IAS officer at that time, who was heading this department, Chaitanya Prasad sir, IAS officer. He was this Controller General of Patents, Designs and Trademarks. Okay, so just like you have FER in patent, similarly you have FER in design. So for design part, the term of design is 10 years, and again, this request for renewal should be within 10 years, and request for restoration of lapsed design should be within 1 year of date of cessation. So these are restoration things. This will come back later, like restoration and all. Okay, so what is restoration? Say for example, you are having a patent in design, And after getting your patent, you feel that, okay, I'm filing this renewal fees again and again, but this patent is not making me, is not generating much income for me. So what should I do? I'll stop paying renewal fees. As soon as you stop paying renewal fees, your patent gets seized or your IP right gets seized. Then after that, you apply for restoration of patent. So what is the form for that? In patent, it is form 15. So form 15 you file and you restore your patent. Okay. So the next is trademarks. So trademarks is logos. Okay. What was patent? Patent is some technology involved. What is design? Shape, configuration, pattern, or some kind of ornament design. So that would come under design. Trademarks is logos. Logos, collective marks, certification marks, slogans, sound marks, shapes. This all comes under trademark. So can you tell me this M sign over here? This yellow M sign and red background. Yes, McDonald's. So this comes under McDonald's. Again, you must have seen this so much time. Yes, Puma. Yes, right answer. Some of them was Puma, and this you can see Nike over here. The tick mark, the black tick mark, that is Nike. And you have this Metro Goldwyn Mayer. You must have seen it in childhood during maybe watching Tom and Jerry, maybe. You see this roaring lion of MGM, Metro Goldwyn Mayer. So that is also a trademark. So that also comes under slogan, sound marks. Okay. And also slogans. Slogans, for example, ye dil mange more. It's of Pepsi. So that is also a trademark. LG Life's Good is also a trademark. Okay. Like you have Dharma Productions, the starting tune is there. Production house is also the starting tunes, like you have Columbia Pictures, like you have Dharma Productions, etc. So those starting music which comes, that is also protected under trademark. Okay. The question over here is, okay, can you tell me the slogan for McDonald? McDonald का क्या slogan है? I'm loving it. Yes, Rishit Patel. Yes, right answer is I'm loving it. So this is a McDonald का slogan. A slogan for say KFC. KFC का क्या slogan? Any answers? Yes, it's finger licking good. Priyanchu, yes. Answer is finger licking good. Okay. So everyone like is like aware are in like well updated about social media platforms. So here you can see the example over here where Facebook has changed its name to Meta. So Mark Zuckerberg, the chairman or the CEO of Facebook, what he has done is he has changed his name to Meta. So once you open Facebook, Instagram, WhatsApp, you see this from Meta written over here. So what is this Meta? Meta is like Mark Zuckerberg told that in his recent interview, he has said that metaverse is a thing of the future, like the things like artificial intelligence, robotics, Internet of Things, edge computing, cloud computing. So these are the next gen technology. So metaverse, he has changed his name to Meta. So this happened in front end. Okay. So what he has done technically, he has changed his trademark from Facebook to Meta. The Facebook has changed its name to Meta. The Facebook has paid around $60 million to acquire trademark assets from Meta Financial Group. Okay, so what Facebook has done is he has paid around $60 million to just to acquire this four-letter word Meta. Just to acquire this four-letter word Meta, Facebook has paid around $60 million to a South Dakota bank. If you must have seen this news report over here, South Dakota bank, they have paid around 60 million, which is equivalent to say 400 crores. 400 crores to just to get this four-letter word. So you can imagine, suppose for example, if you want, if you have designed a trademark and for like by chance maybe the person like people working in Facebook or in Google are interested in your trademark, you can be multimillionaire overnight easily. Okay. So can you tell me what's wrong here? Yes, the spellings. Yes, the spellings are wrong, and it is you will say a fake trademark. A Colgate should be Colgate, should have been Bisleri, should have been Puma. Okay, fake trademarks. Yes. So these are more examples. Like we have more examples over here: Belsri, Bilseri, Bisleri, Brisley. So these are distinctive and not deceptively similar. Good, it's a good trademark. This you can see over here. This is the Bisleri is the correct trademark. So it is distinctive in nature and not deceptively similar. The another case studies of Roo Afza and Dil Afza, where this Roo Afza you see over here, this is a original one, and Dil Afza had applied for a court case. This Roo Afza had applied a court case, filed a court case against this Dil Afza, claiming that they have infringed their trademark. Okay, and later they were awarded some compensation and all in High Court. Okay, so the story goes on like that. So trademark, what are the keywords over here? Name, symbol, or device, logos. Okay, what it does, it builds public goodwill and brand reputation, and it identifies the source and origin of goods. So, for example, you're driving, say, in Mumbai Pune highway, for example, and left hand side, right hand side में आपको M का साइन दिख रहा है. तो M का साइन दिखने से आपको क्या स्ट्राइक करता है माइंड में कि it is भाई मैकडोनल्ड का आउटलेट है इधर. There is a McDonald outlet over here. So you are identifying that source and origin of goods. Okay. So in just on the right hand corner of your trademark, you will have this either TM sign or R sign. TM is that it is application is pending, that you have registered your trademark, but it has not fully got accepted. R means it has been fully registered. Okay. So patent के लिए क्या था? What was the validity of patent? It is 20 years. Design के लिए 10 years. For trademark is 10 years and can be further renewed indefinitely. So trademarks is Trademarks Act 1989 and Trademark Rules 2017. Okay, so these two you need to have keep in mind: Trademarks Act 1999 and Trademarks Rules 2017. So for more information, this is our official website, IP India. You can visit that. Okay, so what is copyright? So we've seen 3 IP rights as of now. One is patent, another is trademark, another is designs. So the 4th IP right of the day is copyrights. So what is copyrights? Copyright is literary works. Literary works, maybe a novel published by Chetan Bhagat, or a novel published by say Kushwant Singh would fall under literary works. Dramatic works, sound recording works, artistic works. Artistic works may be the painting done by M.F. Hussain. It will come under artistic works. Musical works would be work done by A.R. Rahman. He has composed on YouTube. So it will come under musical works. Cinematographic films also come under copyright. Okay. So this is this famous Three Idiots controversy. What happened in this Three Idiots controversy is that Chetan Bhagat, the novel of the this 5-point summer, this author of this 5-point summer novel, what he has done was he had filed a case of copyright on producer and director of this film Three Idiots. Later, the matter was solved by giving credit of story to Chetan Bhagat. So he was paid around 10 lakh rupees as compensation for rights of the film. So what he has done is that he has copyrighted his novel, and by that way he could earn 10 lakhs with this copyright. Okay. So what is a copyright? So copyright is a bundle of right or automatic right, and important sections over here, section 2I and section 13 of copyright rights. Okay. So main things, the basic thing is that if it is involved some kind of musical works, artistic works, sound recordings, so that would come under copyright. Okay. Also, another thing is that if you are having a source code, like the person someone had pointed out what is the source code, the source code would also fall under copyright. Okay, so who is the first owner of copyright? Okay, who is the first owner of the copyright? Copyright first owner is literary or dramatic work. Music work is music composer. Artistic work, then other than the photograph, is the artist. So photograph is person who is taking the photograph. Cinematographic film is the producer himself, not the director. The producer himself. Though Chetan Bhagat had filed a case against the director and producer of Three Idiots, but producer is the first owner of the cinematographic film, the film which you watch in theaters. So who is the owner of that film? The film is producer. Okay. Literary, dramatic, musical, artistic work which is computer generated, the person who causes the work to be generated. Okay. This is a matter of again contention that AI should be given patents or not. So in India, the person who who causes the work to be created is getting the patent. Okay, so it should be an actual person. Okay. Okay, photograph. The person who's taking the photograph. Say in social media, you must have seen like your friends, your relatives asking for pic credit. Pic credit, though, pic credit, though. Pic credit means who's taking the photograph. Okay, he is the first owner of copyright. Okay. So these are some validity. Cinematography films is 60 years from date of publication. Broadcast reproduction is 25 years. Performance is to 50 years. These are some like basic theory. Okay. And lifetime of author plus 60 years. This is for literary and dramatic works and musical works. For example, say Michael Jackson, like he died in the year 2008 or 9, I don't remember exactly. In the year 2009, and but his works, the music he has composed, the dramatic works, the dance steps he has performed, everything is the copyright is valid up till 2069. Why 69? Because lifetime of author plus 60 years. Okay, that is for copyright for lifetime author plus 60 years until 2069, the copyright is valid. So the application procedure for this copyright is Form 14, and you can either file it by e-filing mode or you can file it in copyright as copies by person, and payment can be made in form of payment gateway or DDIPO, etc. So some of the fee details over here, I won't go much into it. Like literary is 500 rupees, sound recording is 2000. It depends on your application. What is your fee detail? I won't be able to perfectly tell you what would be the fees for a particular IP right. That depends on your application. Okay. So geography indication. So this is the final IP right of the day, geography indication. Invaluable treasures of Equatorial India. So I'd like to show a video over here. Just a second. Is the sound audible? Okay. Okay. Okay, this video is about GI, geography indications. You learn a lot about the different GIs which are there in India, and GI office is in Chennai. Okay.
चिंदी चोर के साथ घमासान के बाद अब आईपी नानी बिजी हो गई अपनी पोती की शादी की तैयारियों में। संगीत वाले दिन जब छोटू उनसे मिला तो
वाओ नानी, आप तो बिल्कुल छाए हुए हो। आपके सामने तो मधुबाला को भी कॉम्प्लेक्स हो जाए।
ओए, मस्का लगाना बंद कर। ये बता तुझे क्या चाहिए?
नानी, आपने तो मेरा दिल ही तोड़ दिया। क्या एक प्यारा सा लाडला सा बच्चा अपने नानी को कॉम्प्लीमेंट भी नहीं दे सकता?
अच्छा चल, एक्सेप्ट किया तेरा कॉम्प्लीमेंट। अब बता तुझे क्या चाहिए?
मुझे कुछ नहीं चाहिए, बस आपके हाथ की वो स्पेशल वाली चाय पीनी है।
बस इतनी सी बात के लिए इतना बड़ा मस्का?
मस्का नहीं नानी, आप आज सचमुच बहुत ही रॉकिंग लग रही हो। ये साड़ी आप पर बहुत ही अच्छी लग रही है।
अरे ये तो स्पेशल लखनवी चिकनकारी है। लखनवी चिकनकारी पूरी दुनिया में मशहूर है। ये अपनी खूबसूरत और बारीक एम्ब्रॉयडरी के काम के लिए फेमस है। लेकिन पता है इसकी सबसे बड़ी खासियत क्या है?
क्या है?
ये एक रजिस्टर्ड जीआई है।
जीआई? वो क्या होता है नानी?
जीआई का मतलब होता है जियोग्राफिकल इंडिकेशंस, हिंदी में जिसे भौगोलिक उपदर्शन कहते हैं। ये किसी समुदाय का बौद्धिक अधिकार है, वो विरासत जिन्हें प्रोटेक्ट और एनकरेज करने की बहुत आवश्यकता है। मुख्यतः इन टाइप्स में रजिस्टर्ड होती है: नेचुरल गुड्स, मैन्युफैक्चर्ड गुड्स, टेक्सटाइल्स, हैंडीक्राफ्ट्स, फूड स्टफ।
अच्छा।
चल अब ना किचन में चलते हैं और गर्मा गर्म चाय बनाते हैं।
हाँ हाँ हाँ।
किचन की ओर जाते हुए नानी ने छोटू को अपना देश घुमा दिया।
छोटू,
जी नानी।
ये देख, ये पेंटिंग देख। ये एक मधुबनी पेंटिंग है, बिहार की। और ये है हिमाचल की कांगड़ा पेंटिंग। तेरे नानू को देश की कला और संस्कृति से जुड़ी हुई चीजों को इकट्ठा करने का बहुत शौक है।
अच्छा।
ये कठपुतलियाँ देख रहा है?
हाँ।
ये राजस्थान की हैं। इसी तरह छत्तीसगढ़ से बस्तर ढोकरा, आंध्र प्रदेश से तिरुपति लड्डू, असम से मूगा सिल्क, नागालैंड से नागा मिर्च और मध्य प्रदेश के बाघ प्रिंट, ये सब रजिस्टर्ड जीआईज हैं।
ओके।
ये हमारे देश की कला और संस्कृति का प्रतीक है। हमारे देश में हुनर और कला का इतना भंडार है कि अभी से ही 300 से ज्यादा रजिस्टर्ड जीआईज हैं।
वाह नानी।
चल अब तू चाय बनाने में मेरी मदद कर। एक बर्तन में पानी ले और उबालने के लिए रख।
यस बॉस।
पता है छोटू, तुझे मेरे हाथ की चाय इतनी पसंद क्यों है?
क्यों है नानी?
क्योंकि ये स्पेशल दार्जिलिंग की चाय है। ये देश की सबसे पहली रजिस्टर्ड जीआई है, जो 2004 में रजिस्टर्ड हुई थी।
लेकिन नानी एक बात बताओ, इन जीआई से फायदा क्या होता है?
देखो छोटू, ज्यादातर जीआईज गांव के समुदाय के होते हैं। इनसे कारीगरों, बुनकरों, किसानों की आमदनी बढ़ती है। उनको अपनी मेहनत का सही दाम मिलता है और उन वस्तुओं की डिमांड भी बढ़ती है। साथ साथ खरीदने वालों को भी विश्वास हो जाता है कि वो एक जेन्युइन चीज खरीद रहे हैं।
ओह, वैसे नानी मुझे एक आइडिया आया है।
अरे वाह छोटू, तेरे को आइडिया?
यस नानी, अगले महीने फॉरेन से मेरे कुछ दोस्त आ रहे हैं। क्यों ना मैं उन्हें हमारे देश के कुछ सुंदर जीआई प्रोडक्ट्स गिफ्ट में दूं?
ये तो बहुत ही अच्छा आइडिया है छोटू। उन्हें ये चीजें जरूर पसंद आएंगी और हमारे देश की कला का नाम भी होगा।
देखा नानी, आपकी संगत में मैं कितना इंटेलिजेंट हो गया हूँ।
हाँ भाई, ये बात तो है।
और इस तरह एक बार फिर आईपी नानी ने आईपीआर का झंडा ऊंचा लहरा दिया।
Just a second. Yeah. So I'll continue my presentation. So we have this geography indications. Geography indication, like, it identifies a product that is specific to that geographic region. Like, for example, you have Darjeeling tea. So it belongs to Darjeeling, okay, and it has some particular qualities where you can say this soil content or this particular climatic condition of that tea, which says that, okay, this tea is still different in taste compared to, say, a tea from a tea garden in Kerala. Okay, So that it possesses some qualities or reputation that are due to the origin. Like for example, you have Madurai Malli, you have Wayanad Jeera Kasala rice, Nilgiri tea, Bastar Dokra. So you have a lot. You must have seen a lot of examples in this video also. So some of them examples over here is Makrana marble, Ratlami save, Kanchipuram silk, etc. So can you tell me this Ratlami save? Ratlam is from which district in India? Belongs in which state? Any answers in chat box? Yes, then my answer is MP. So I got a question over here. How do I register a startup? Okay. Startup registration, you need to visit Ministry of MSME. Okay, they would issue a certificate. So startup has particular conditions over there. I'm working in Ministry of Commerce and Industry. So that belongs to different industry. That belongs to different ministry. So that ministry is the Ministry of MSME. So startup के लिए कुछ conditions है. Like for example, you should be within 10 years or of date of incorporation. Then after that, you need to have particular turnover, etc. So you need to satisfy this condition. So you'll be declared as a startup. And after you have been declared as a startup, then you can come to patent office and then apply for a fee concession through Form 28. Okay, and then so before that, I have to register it as a company. This detail you can get it from Ministry of MSME. This I won't be able to tell because mine is totally different. I would be able to tell you what IP management you can make as a startup, but you need to register as a company and then you must have go to declare it as a startup. So startup has added benefits compared to a normal company. Yeah. So Ratlam is in Madhya Pradesh, Ratlam, and Ratlam is safe. So Madhya Pradesh you must have known is Indore. It's a place in Madhya Pradesh where it is famous for namkeens. Okay. Kanchipuram silk, it's in Tamil Nadu. Kashmir saffron, Devanali pomelo, Coorg orange, Chai lychee of Bihar, etc. So next time if you say walk into a restaurant, just try to you must have ordered before in past maybe Kashmiri pulao. You must have, if you have ever tasted Kashmiri pulao, in that Kashmiri pulao, the ingredients are basmati rice, Kashmir saffron, apples, and some kind of cherries, etc., which makes that pulao sweet. So those ingredients are cultivated in the foothills of Kashmir. So that is why it is so famous that Kashmir saffron, Kashmir apples, they are famous. Okay. Just like you have Shai Lychee of Bihar, Coorg orange. So can you tell me Coorg is in which state in India? Coorg is also famous for coffee. Any answers in chat box? Coorg, Karnataka. Yes, Rishit Patel. Yes, it's Karnataka. Tanmay, yes. So it's Karnataka. So I'll show you another video where you find that IP is everywhere. Yeah, just a second. Yeah, so this is a summary slide where we saw five IP rights like patents, designs, trademarks, GI, copyrights. So what was patent? Patent was some technologies involved, some kind of this is okay. Now you are having an IP in your disposal. Say, for example, you are having a startup. So for the startup, you need to design a logo. Okay, you need to design a logo. So you need to protect it under trademark. Okay, so what could be the startup idea? Startup idea could be anything. Okay, so you have some kind of design aspect to that. You can have to first segregate all those products which you are producing through your startup into maybe either as a copyright or a GA or a trademark or design or patents. Okay, so what I have done is that I have given you tools. I have given you tools as to okay, these things are called patents. These things are called designs. This thing is called trademark. The logos, etc., come under trademark. GI, I have given you as a knowledge purpose, but GI, if you are maybe in a particular industry where suppose GI is involved, over there GI might help you, but for a common technological tech-oriented startup, GI won't be that much useful. Okay, another is copyright. So lifetime of author plus 60 years. So this is a validity of each of this IP right. So patents is 20 years, design is 10 years plus 5 years. So trademarks is initially for 10 years. Copyright is indefinite subject to renewal. Copyright is lifetime of the plus 60 years. So who can apply for these things? It could be a person, it could be a legal representative, it could be a startup, it could be a small entity, it could be a partnership, it could be an education institute. Okay. So all IP rights are territorial in nature. As I said earlier, if you want an IP right in India, you need to go to Indian Patent Office. So it is territorial in nature. Okay. So where to approach for protection? You can file it online also. There's no need to come to office and then apply it offline in an offline way. It's not needed. Now it's a time of digital India, so you can apply it through online also. Um, this is the training institute RGNIPM where we got trained as examiner of patents and designs. This is for 6 months training we underwent. This also is open for public also. This training for college. Apart from it, you have this 4 patent offices: Mumbai, Chennai, Delhi, and Calcutta. Design office you have Calcutta. GI is in Chennai. Copyright is also in Delhi, and trademark office you have 5 offices over here. Okay, this is the IP India website. You can see over here it is beautifully like decorated, like patents, designs, trademarks, GI, RGNP. You can just click on that and you can go for comprehensive filing over here. Okay, so some of the career opportunities. So this is one of the important slide I would feel. This career opportunities you can if you want to come to government sector, you can apply for examiner of patents and designs. Now the application is still going on. The date is it's not yet ended. This time it is conducted by Quality Council of India. So examiner of patents and designs, group A gazetted, it's equivalent to an IAS officer post, level 10, and around 553 vacancies have been released this year. So, and the basic qualification is you should have an engineering degree particular to that field of technology. For example, I am working in metallurgy, so you need a BTech in metallurgy. If you are working in say computer science, you need a BTech in computer science. If you are working in say chemistry, I think the qualification is either BTech in chemical engineering or MSc in chemistry. So you have to look through that notification exactly for what eligibility you require. Apart from it, you have examiner of trademark and GA. For this, you need law background. Suppose say you don't want to work in government, you want to work in private sector. You can be a patent agent where you can file applications on behalf of inventors and you can prosecute those applications in patent office. So again, you have trademark agent, you have patent facilitation centers, and you have patent litigation and opportunities in private sector. So you can be a patent agent and still work in a startup and then accept applications from other this one. That could be a new startup idea. Patent agent, maybe a patent agent opening a startup, that could be a new startup idea for you. Okay. So this is the RJNFM details. This is a technical college where we underwent training for a period of 6 months. So time for some quiz. Okay, so you can type your answers in chat box. This is a very simple basic quiz so that I can get a feedback regarding how much I'm able to communicate what are those basic IP rights. Okay. So which type of IP protects the painting painted by artists? So as I told the example of M.F. Hussain, So M.F. Hussain has painted a new painting. So that would come under which IP right? Any answers in chat box? Is it copyright? Is it GI? Is it patent?
So wait a minute. We have disabled the chat box. We'll enable it right now so that we can see the.
Okay.
Chat box is enabled. All of you give your responses over there.
So painting, yeah, painting. Aishwarya, right answer. Sneha, answer is copyright. Copyright is the right answer. So painting, musical works, painting works, artistic works. So that would come under copyright. Shambhavi, Pratik, Sivadarshini. Yeah. Oh, yeah. All of them. Right answer is copyright. Okay. What protects the intellectual property created by fashion designers? So this question is very easy. You can find the answer in the question itself. So Varun, yeah, right answer is design. What protects the intellectual property created by fashion designers would come under design. So you being an entrepreneur, you need to first identify what IP right it falls under. Then after that, you can take appropriate actions. Okay. In India, the problem is everything is a patent. No, everything is not a patent. Even if you have a logo, they'll say आपने patent किया क्या लोगो का patent किया क्या नहीं ऐसा नहीं होता patent नहीं वो trademark है वो. So that is a basic understanding you need to get first of all. You being maybe a student in the college or a budding entrepreneur, you need to know this thing. That what is this intellectual property first of all. Okay, Sneha, yes, answer is designs. So what protects the advanced disc brake for bike developed by inventors? So there is some kind of technology involved over here. Advanced disc brake. So and there's another this is inventors. So there is something known as true and first inventor. Section 2I of Patents Act talks about inventors. So this is patents. Yes, Rishit, Aishwarya, Om. Yeah, answer is patent. Patent is the right answer. Yeah, patent is the right answer. Which of these is a geography indication? इसमें geography indication क्या है? Geography indication is as a group of people had come and yeah, Nagpur orange, yes. Aishwarya, Sneha, answer is Nagpur orange, yes, right answer. What does a trademark protect? So trademark is like the M sign over there. So what is that M sign? That McDonald's sign. Yeah, logos, names and brands, yes. Varun, right answer is logos, names and brands. Rishit Patel, yes. Om, yeah. Answer is logos, names and brands. So how long can a patent last? So what is the validity of a patent? Yes, 20 years. Pallavi Nayak, Pratik, yeah, answer is 20 years. So if you write an original story, what type of intellectual property gives you the right to decide who can make sell copies of your work? So some of the keywords over here are story, make sell copies of your work. So it would come under copyright. Yeah, it would come under copyright. Aishwarya, Pratik, Mansi, yes. Answer is copyright. Yeah, so the next question is, if a company develops a new technology that improves its main product, what type of intellectual property can they use to stop others from using their invention? So keywords are technology, invention. So it would be patent. Yes, patent is the right answer. Patent is the right answer. Yeah, so these are some general helpline queries. We have a dedicated help desk team where we to answer your queries regarding anything. It could be related to patent or it can be related to trademark. Yeah. Yeah, the answer for the last question was patent, yes. So thank you so much. If you have any questions, you can ask. Sir, is it possible for you to connect me with examiner of copyrights who can help me with filing copyright for source code of my mobile applications? Yeah. Yeah, sure. But copyrights office is in Delhi and I'm working in Mumbai. Though I do have contacts, I'll let you know. If you have any query, I can pass on to him and I'll let you know. Source code के लिए copyright होता है. Source code के लिए there is copyright. Okay. It's not, it won't come under patent, it will come under copyright for sure. That I'm sure of. Yeah, any other questions? Sir, to do games come under patents. Okay. Games do not come under patents. It would come under maybe yeah. Okay, games come under patents. It would come under more under copyright more than patents because there is no technology involved in that. Okay. If you are doing some kind of inventive step which is different from this one. So games means what? Games is just a one huge product. In that games you would have a lot of source code. You would have some kind of visual effects. So that would come under design also. So as I showed of the first example of a TV. Okay, I have explained it very simply. This slide, I explained it very simply so you can understand very easily what is the patent, what is the trademark. So games is itself a huge product where you will find a lot of things like copyrights, designs, etc. Okay, you'll have a lot of source code in that. You'll have a lot of design aspect, visual design over that. You will have a lot of just a second. Yeah, you will have a lot of other IP rights also involved in that. Okay, so if you say specifically, if you ask if it's under patent, I would say no, it won't fall under patent. Just a second, I'll answer one by one. Yeah, if we add a new feature to already patent product, can we patent it to a new product? Yes, you can. There's something known as patent of addition. Okay, where you apply for a new additional product over the existing patent. That is called as patent of addition. It could be very possible that you have a parent application, you have a child application. This parent application has already been granted. This child application is a new feature of the existing patent product. So that you can patent it. But if you apply as a single different parent one, it would kill the novelty. I can easily cite yours and says that it is not novel in nature. Okay. So you can do that. That is something you file a patent of addition application for that. Okay. The concept of copyright claim in YouTube over content. There is so much uncertainty in this. Can you explain about it? Okay, yeah. So copyright is like you have a copyrighted product, and then you, while uploading your video on YouTube or something, I haven't seen exactly, but you would have a copyright name. Someone who says that this copyright is belongs to me, and he has, say, for example, official music record. Okay, like a famous music song. Maybe Shah Rukh Khan is dancing that music song, and you have taken that clip and you have uploaded in your YouTube this one. So that is a this is a pirated one because we have no copyright of that claim. Okay, so if anyone objects to that, YouTube would remove that content, citing copyright claim. Okay, yeah. I hope I answered all your questions. Any other questions? Can you give your email? Shall I come to your office for any query? You can come to the office, no issues. You can. I'll share the email to madam. Madam will circulate your email ID. Yeah, and my email ID is available in. This is a government office. I have nothing to hide. It's in government. This one you just visit IP India and you can just type my name. You'll get the email ID. Yeah. Any other questions you have?
So just checking in with you.
Yeah.
Is the question Q&A round over?
Yeah, I think no more questions have been asked. Questions you want to ask, please ask.
Okay,
Do you see any
all of y'all,
questions here?
if you don't have any questions, we will proceed and conclude. the event. So I don't think there are any. So should I just start? Okay, everyone. On behalf of TCET ACM SIG-AI student chapter, I extend my heartfelt gratitude to all the student faculties from different colleges around India for being a part of this remarkable online seminar on intellectual property rights and IP management for startups. Your active participation and engagement have made this event an insightful and enriching experience for all of us. A special note of appreciation to our esteemed speaker, Mr. K. Narayanamurthy, for sharing his profound knowledge and expertise in the field of patents and intellectual property. His valuable insights have undoubtedly expanded our understanding of this critical domain and significance for startups. We would also like to thank our principal sir and all the deans for giving us this prestigious platform and thus enabling us to make this extensive knowledge available to students all over India through the medium of this event. We would also like to thank Dr. Megha Rani Patil ma'am, the HOD of AI/ML at TCET, and Ms. Rupinder Kaur ma'am, professional body coordinator for the ACM SIG-AI TCET, for their impeccable guidance along the way. We would also like to express our sincere thanks to all the members of ACM SIG-AI core who worked tirelessly behind the scenes to make the seminar a resounding success. We conclude this event encouraging all the startups to leverage the knowledge gained here to navigate the complexities of intellectual property rights and maintain their innovations effectively. Once again, thank you everyone for making this event a memorable one. We look forward to welcoming you all for more such gatherings in the future. Let us continue to grow together, fostering innovation and advancing in the world of AI and intellectual property. Before we end today's session, I would like to announce that on 11th August 2023, we are organizing a session on innovation startup ecosystem enablers on regional, state, and national level in online mode. The registration would be floated soon. So all of you all stay tuned for that as well. And thank you and have a great day. I'll also be adding a feedback form and assessment quiz in the chat box. So please make sure to fill out those forms as well. Yeah, thanks a lot.
Yeah, thank you so much. Thank you so much for patiently hearing. I hope you got those questions answered. Yeah.
Yes, sir. All of you all make note that these links are also added in the WhatsApp group. So you can also access them from there. So if all of you all are done with filling the forms, you all can leave. Yeah, the meeting is over. Thank you.